We'll
Since
see.
we've
Yes.
updated
My
the
lords,
ECIR,
without there being a
there's an addendum.
No, earlier it was said that there is one more crime
My
pending.
lords, absolutely not. If an ECR proceeding is done only to defeat the investigation in ECR, if you're trying to compromise a predicate offense, you will stand on a different footing. Here it is not so.
Initially, on 21st July, when the ECR was registered, on that day, this Harrow Valley affair was not in the picture. It was brought in by way of addendum. Initially,
That is
everything was-
exactly the point. Whether by way of an addendum, can you update the FIR is what is to be answered.
That's
Let
the
him
question.
come.
That's
Lords,
the
my
question.
submission.
There are three division bench judgments of three different high courts
Please,
on
please.
this issue.
My lords, my submission in 69 case, my lords.
Now there are two judgments.
No, my lords, my
Now
sub-
is there and then Bombay is there.
My lords.
Delhi also is there. In fact,
Yes.
there are four judgments.
Now, my lords, my
Alright.
submission. Not now.
Which B report is pending?
Predicate offense.
Addendum.
No, predicate offense.
Superstructure is gone.
No. We will show that, lordship. In any case, my lords.
No, there is one crime in which B report is yet to be accepted.
Please,
Correct.
Addendum.
Please.
One crime where B report is yet to be accepted. So it cannot amount to closure of the criminal
Please.
proceedings unless B report
Please.
is accepted.
Please.
Correct? That's very rudimentary.
Please.
All right. See, if that is there, so there is still a predicate offense.
And there's no question of addendum at all.
My lords, ECR was not there. He got his money back.
This jurisdictional police will not do anything.
My lords, he has got his money. He's satisfied with it. ECR has not begun. At least it's ECR has sprung into action. The situation is different.
Will nobody present?
Lords,
Pappi.
I'm in 69. Yes. 87, they connected. 87 is Gamescraft. We can start with 69, my lords. Issues are common, my lords.
87? That we'll see. Attachment proceedings.
Caesar, in my case, my lord, Caesar.
Nim
My
Castle.
lords, ours is a case where the B report had been accepted. Post that after about 3 months comes the ECIR. ECR could not have been initiated at all. So, my lords, on the last occasion, I had given
No,
certain.
in that the other thing B report was like 6 years admele they have come. No, that is grandmother.
Adu abatement. My lords,
Abatement.
abatement. Adike. But
Here I don't think we should.
in both these matters, my lords, here, I'm sorry, my lord.
Let the ECIR go on. Whatever proceedings are there, let it go on.
My lords, without there being a predicate offense.
We'll
Since
see.
we've
Yes.
updated
My
the
lords,
ECIR,
without there being a
there's an addendum.
No, earlier it was said that there is one more crime
My
pending.
lords, absolutely not. The second FIR which they're talking about Lucknow was registered post the ECIR, and that too, my lords, more importantly, not on a schedule offense. That's under the IT Act, which is not a schedule offense. So both ways we look at it, my lords, the second FIR absolutely has no bearing to this. My lords, I'd like to point out from the Act itself. Now, if we are not going to be having a schedule offense, we can't have an ECIR at all.
Nah. We'll see.
My
IT
lords,
Act is
could I-
there in-
could
Because there are three division bench judgments
No, my lords, could I
of three
explain
three different high courts saying they're entitled to update the FIR.
My lords, could I just explain on the act itself? Updating is here is not a case of updating. My lords, here updating on a matter which is not a schedule offense, that can't be done. My lords, can I just explain once, my lords, about multiple FIRs? Now, if there are going to be multiple FIRs, let's take an instance, my lords. There are about 5 FIRs in 5 different territories. Now, all these FIRs leads to proceeds of crime. Now, this proceeds of crime, my lords, is used within the jurisdiction of Bangalore for the purposes of laundering. Then, my lords, is the instance where we can say you can take the aid of the 5 FIRs that are registered.
Now you have challenged ECIR summons, is it?
No, I've challenged the entire proceedings of the ECIR.
No, what stage it is? Is it?
In my case, my lords, complaint is yet to be filed.
So the proceedings, how can you challenge it now here?
ECIR proceedings, my lords. My lords, Vijay Madanlal Chaudhary makes it very clear, my lords. Without a schedule offense, we will not be able to have.
There is development of law after Vijay
I will point
Madanlal.
out even, my lords, could I for a minute, my lords, point out from the act itself. Let us see, my lords, from the act, how the act is structured. The entire act, my lords, in my respectful submission, is structured on the basis of the need to conduct trial and there being an order of conviction. So, my lords, if there is going to be an order of conviction, 2 consequences. One, there would be a punishment under section 4. 2, my lords, there would be confiscation of the property under section 8(5). Now, during this period, my lords, what section 5 and 8 only does is it protects the property. My lords, section 5, provisional attachment, 8, confirmation of the provisional attachment. Now, if you want to have this property confiscated, similar to how we have our criminal law ordinance, my lords, of 1944, there also schedule offences, initially attachment orders. Now you await the outcome of a trial. In the trial, if there's going to be a conviction, then comes the stage of the central government.
You're also on the same footing. B report,
We report, my lords. In our
in
case,
your case also.
Yes.
B report is accepted.
My lords, on that, initially when the search was conducted on that,
Lords, on that
day,
point-
my lords, initial ECR was issued, all
Lordship.
FIRs were closed.
So
Subsequent-
closed how?
Either acquittal, discharge, there is no dispute there.
Acquittal
Subsequent-
discharge, not a B report.
Not B report, acquittal, discharge, my lords. Subsequently, what they have done, they have added.
So, nim case ಅಲ್ಲಿ B report.
My case, my lords,
B report, correct.
my case, B report, acceptance of the B report.
B report,
There's a
correct.
statement he accepted cash, my lords, for the B report.
That's precisely
Complainant
why
himself
that
filed
those
the
B reports.
My lords, on the last
Filed to
occasion, my lords, on the last
No,
occasion.
if it is acquittal discharge,
My
we'll
lords,
see,
I have-
because
I
those
have
are
one
orders of the court, this is on a concession that is made.
My lords,
That
on
the complainant accepts money, closes the proceedings and everything gets.
My lords,
lords,
one,
You win over the complainant.
my lords, one
my lords, on the
submission.
last occasion, the same question that was asked, my lords. Now, if it is going to be a case where B reports are accepted at an undisputed point of time before the ECIR proceedings are initiated, it stands on a different footing. The court also noticed if an ECIR proceeding is done only to defeat the investigation in ECIR, if you're trying to compromise a predicate offense, you will stand on a different footing. Here it is not so. Here it is a case, my lord.
No, I asked a question saying, yes, during the subsistence of the B report, if the ECIR is registered, then it is closed, it stands
That's
on a different
different.
footing.
Here it is not
But
that, my lords.
this is not also on a strong footing
My lords,
because
When
lords,
the
if I may
ECR
s-
gets registered, which is a
ಆಯ್ತು ನೀವು
predicate.
ಎಲ್ಲ the complainants will be bought over. Cash ಕೊಡ್ತಾರೆ close.
My lords, 420 case ಈಗ ಇರುವಾಗ compounding they won't do, my lords. Even before this court, compounding doesn't happen. At the time when there's no ECIR.
No, you
Compounding-
stand on a different footing.
My
My
lord,
lords, so in that point, my lords, on that point, as what, in 69 matters, lordship, in that, there were 4 predicate FIRs. In that Harohalli FIR, for which B report has been filed. 1 minute, sir, 1 minute.
ಆಯ್ತು.
B report has been filed and not yet accepted. My point is, my
No, he
lords,
says acquittal and discharge.
no, 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 no.
May I say this?
I may submit it, 1 minute, sir.
I'll get, don't worry.
B report has been filed, it has not been accepted. Our only submission is, of course, ASG is coming, but madam, there is a
Let
judgment
the
by my,
ASG come. We'll pass it over. Let the ASG come.
lords, if I make a
my lords,
submission,
anyway, let him come.
May I just say,
In
lordship,
case
one,
ಅಲ್ಲಿ you won over the complainant.
My lords, it's not a case of winning over the complainant when an ECR is not registered. My lords, am I to anticipate that in the future an ECR will be registered at the time when I compound the offense?
We'll see. Yes.
My lords, that's the reason on the last occasion, my lords wanted to know, is it a situation where during the pendency of ECIR, you have compounded the offense? No. If, my lords, in a case of cheating, if there's a compounding, my lords will definitely allow the compounding, my lords, based on Gyan Singh's case.
my lords, in one case, my
Now,
lords,
this is a case like that. My lords, where a B report has been accepted, complainant has no objection for the accepting state.
Why?
He has accepted cash.
My lords, ECR was not there. He got his money back.
This jurisdiction police will not do anything.
My lords, he has got his money. He's satisfied with it. ECR has not begun. At least it's ECR has sprung into action. The situation is different. And I will point out, my lords, from the act itself, my lords, from the provisions of the act, I will be able to demonstrate this ECR could not have been registered.
my
How
lords,
do we
one sub-
register
one-
an ECR without there being a schedule offense, my lords?
We'll
one
pass
su-
it over.
my
Let
lords,
the
one
ASG come.
submission on facts with respect to 69th matter.
ಹೌದು.
My lords, in that, there are 4 FIRs. In the 4 FIRs, one FIR B report has been filed. It has not yet been accepted. Now, my
ಅದು
lords,
ರಜತ್ ಕೇಸ್ ಅಲ್ಲ?
on point of law, my lords,
Well, not accepted is no quashment, no clearance of predicate at all.
my lord's own order, my lord's own
Not
order.
yours, wait.
My lords, my lords,
B report is not accepted.
what is not accepted? My lord's own order. There's
Not
no case for them.
accepted, no predicate, you can never say.
My lord's own order in 2021, my lords, B report needs to be accepted through a judicial order. And
Yes.
in terms of section 191 subsection
Correct.
B, the magistrate can take cognizance of a B report even if disregarding the contents of the B report is what my lords have held.
Correct.
Supreme Court. So
Correct.
therefore, my lord, that 1 minute, sir, why are you interfering? My submission, my lords, is, my submission is, therefore, my lords, as of now, the offence stands. And with respect to the proceedings which are now before the AA, they can go before AA in terms of the GSW judgment.
Now, may I
So it is not accepted.
Now may I say this, my lords, initially on 21st July, when the ECR was registered, on that day, this Harrow Valley affair was not in the picture. It was brought in by way of addendum. Initially.
That is
everything was-
exactly the point. Whether by way of an addendum, can you update the FIR is what is to be answered.
Lords,
That's
Let
the
him
question,
come.
that's
my lords,
the
my
question.
There are
submission.
three division bench judgments of three different high courts
Please,
on
please.
this issue.
My lords, my submission in 69 case, my lords.
Now there are two judgments.
No, my lords,
Now
my
one is
sub-
there and then Bombay is there, my lords.
No, my lords.
And Delhi also is there. In fact,
Yes.
there are four judgments.
Now, my lords, my
Alright.
submission,
All four stands on a different footing. In all the four cases, there were live FIRs which were closed subsequently.
no, my lords,
Exactly contrary to this case wherein, my lords, the FIR was closed prior to the registration.
We'll
of the
see, we'll
ECR.
see.
my lords, in my case, my lords, in 69, they cannot take that ground because it is not yet closed. It is not yet accepted. Their grounds of subsuming of ECR will come later, not now.
Which B report is,
Predicate offence.
Addendum.
No, predicate offence.
Superstructure is gone.
No, we will show that, lordship. In any case, my lords,
no, there is one crime in which B report is yet to be accepted.
please,
Correct.
Addendum.
please.
One crime where B report is yet to be accepted. So it cannot amount to closure of the criminal
Please.
proceedings unless B report
Please.
is accepted.
Please,
Correct? That's very rudimentary.
please.
All right. See, if that is there, so there is still a predicate offense.
And there's no question of addendum at all.
Of addendum that
So addendum does not matter.
of addendum. Initial registration was all closed.
No, initial registration is closed. By way of an addendum, they bring in a crime in which B report is yet to be accepted.
Exactly.
Correct. Whether that is permissible or not, we'll have to see.
That's the only
Let's
question.
para
Your
26.
case.
In my case.
Then Rajat, same.
Let's para
Purdu
20.
ಬೇರೆ.
No, by case as
Lordship,
mentioned
para
by,
26 of RD Chaitra, it's covered.
ಒಂದೇ ದಿವಸ.
No, no,
My-
notice has been issued by Supreme Court, sir, in that.
That's
Even
okay.
grant of.
No, I will show you one more. I'll give you one more judgment where it says, Lordship, my submission is, in case of a B report, as my lords are aware, let it be accepted.
Unless B report is accepted, it cannot be said the
It's a
criminal
futile
proceedings are
attempt to argue
closed.
on a
There
subsuming
is
of
no
an
doubt
ECIR.
about it.
Issue, my lord.
There is no
The
issue with
question is
that.
Whether they can have addendum or not, because, my lord.
That is the only thing. Addendum is permissible or not, will
I
see.
show it from Vijay Madan Lal, my lords, that it runs contrary to Vijay Madan.
That is
Lal.
considered by division bench judgments and said that.
No, my
it
lord.
can-
Now that is standing now, my lords.
Show, my lords, how the division bench is not, it was on a different footing, and this case is on a different footing, because Vijay Madan Lal is very clear, it has to be such predicate offense.
And my lords, in their case,
Schedule offense, activity relatable to that offense. How can you expand the scope of an inquiry of an
Let's see.
distinct trial?
my lords, in their case, Justice M. Iron judgment is binding. In their case, Justice M. Iron judgment is binding.
ಅದೇನು
My lords, that is with respect to the arrest, my lords, section 19. That was upheld, my lords. And my lords, now they are asking about the 70.
Notice is issued by Supreme Court.
ಯಾವ್ದ್ರಲ್ಲಿ ಜಸ್ಟಿಸ್ ಎಂ ಐ ಅವ್ರದ್ದು
My lords, with respect to their case, whereas in respect to that very case, my lords, my lords, I had submitted the
ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೆಯಾ
He is
ಯಾವ್ದು
not the petitioner.
section, no, case is same, my lords,
ಓ ದಟ್
same case.
ಪಪ್ಪಿ ಇಸ್ ದಟ್ ಇಸ್
Yeah, please. And section 19 is at a higher threshold than section 17.
Supreme Court, the Honorable Supreme Court not saying it is only regarding expunging observation, we'll do it.